So welcome to tonight's program, Legal Issues for Seniors, Practicalities, and Potential Pitfalls. I'm NVN member Faye Ross, and I'm pleased to introduce our two speakers. Dan Ross is my husband, but he's also a longtime member of NVN. And Jackie Rosenberger, the two of them are both attorneys with wide-ranging experience in estate and tax law, as well as more general legal issues of particular interest to seniors. Dan was a partner at the Center City law firm of Drinker, Biddle, and Reith for over 25 years and is now working as a sole practitioner. His colleague, Jackie Rosenberger, Jackie, why don't you wave? I think at least somebody will see you there. There you are. Is with the firm of Barber, Sharp, and Rosenberger, which this year is celebrating its 50th year in Chestnut Hill. Jackie hasn't been with them 50 years, but Rob Rosenberger has. So it's a longtime firm for Chestnut Hill, and Dan's office is also in Chestnut Hill. So Dan and Jackie look forward to answering your questions, but we're a big group tonight. I don't know how many of the 80+ people who signed up will actually be here, but we're not going to be able to see you if you raise your hand. So what I'm suggesting is if you have a question, put it in chat. And depending on the nature of the question, I'll either interrupt at the next easy stopping point, or I'll raise it at the end of the presentation. So for your information, we're already recording this presentation, and everybody is muted, except for Dan, and Jackie, when she starts to speak, will mute herself too. So now, Jackie and Dan, the floor is all yours.
All right, I'm going to share a screen. So tonight we'll be talking about legal issues for seniors and practicalities and pitfalls. Not that we will identify all of them, but we'll certainly try. So Jackie and I are both going to be speaking, and Jackie, if you think I've missed something, feel free to jump in. So first, I want to look at what kind of documents do you need? And I divide that into kind of two areas. One, managing health and finances while you're alive. There are two documents for that. The first is a durable power of attorney. That designates someone to handle every conceivable financial affair you might have. It can be a dangerous document because it gives broad authority. So you need to be very careful who you pick. But if you say, well, I don't want to do that, what you end up with is, if you are in a position you're unable to manage your affairs, then if you don't have a durable power of attorney, someone's going to have to go into court, have you declared incompetent, not a pleasant proceeding, and the judge will decide who's going to manage your affairs. So who would you prefer to make that decision? You or some judge who doesn't know you? It really is an important document. The second is a living will and power of attorney for health care. That document does two things. First, the power of attorney for health care, it says, I designate the following person or persons to make medical decisions for me if I'm unable to make my own medical decisions, to consent to medical procedures. Very important to think about who you choose for that. And the second thing it does is it says, this is what kind of treatment I want if I'm either terminally ill or in a permanent coma. That is your choice, completely what you choose. Most people choose to say they don't want life-extending treatment, but that's not my choice. That is your choice. So people talk about a do not disturb, a do not resuscitate, or a post. Those are not the same as a living will. A post is a physician's order for life-sustaining treatment. And just from that first two words, physician's order, the key point there is Only you and a physician can do it, not you and your lawyer, or not you alone. It can be issued by a physician who decides that you are in either a terminally ill position or in a permanent coma. And it then says no more life-sustaining treatment. So it is really a document that is carrying out the wishes that you might have expressed in a living will. You don't have to have a living will to have a post, but that's a good document to have because it makes it easier for your healthcare agent to go ahead and execute that document. The other type of document is a document for managing and distributing property after your death. There are two documents for that. And remember, the two documents that come into effect while you're alive, those documents cease to be effective at the moment of death. Your durable power of attorney no longer is valid once you die. So your will does two things. Your will designates who you want to receive your property. And second, it says who will be managing my estate, who will be carrying out the terms of my will, who will be making sure that all my bills are paid, who will be arranging for finances, etc. So that's the important what that does. But wills don't govern everything. If you have IRAs or life insurance, those typically have beneficiary designations. When you're reviewing your will, you need to also review your beneficiary designations to make sure that those are also changed to be consistent with your overall plan. We'll be talking about whether you want beneficiary designations for other kinds of accounts in a few minutes. So, some practical issues. As I just said, changing your will does not change who your beneficiaries are under your IRA. That has to be done separately. A second point, are you charitably minded? If so, it's much better to make the gifts to charities from your IRAs, if you have IRAs. Why? Just as distributions you're now taking, because I'm assuming most of us are past the age of 70, I think it's 73, 75 now, to be taking minimum distributions. If not, you'll be there soon. Those distributions are taxable income. Well, after your death, the beneficiaries who receive them, it's also taxable income to them. Well, one type of beneficiary, a charity, doesn't care that it's taxable because it doesn't pay taxes. So that is why if I have clients who have significant charitable goals or even modest charitable goals, I say, do it. If you have an IRA, use your IRA for those gifts. Uh, how often should you update these documents? Well, I could tell you every 3.5 years, every 1 year, every 5 years. But the truth is, there is no simple answer to that question. I do suggest, and I think Jackie would agree, that you want to look at them periodically, maybe every 5 years. But if you've had a major change in circumstances, unexpected death of a child, while you may have thought about that when you wrote your will, maybe when you see the reality after your child has died, that's not quite what you want. So major change circumstances, it's good to take a look at those documents and to decide whether they need to be updated. One thing that we occasionally run into, most bills that come up after death, your credit card bills, etc., they're used to waiting to be paid until an executor is in place and cash has been raised. Sometimes funeral directors say, nope, won't do it until you pay me. Now, if your children have plenty of funds, they can advance the funds and get reimbursed. by the estate. But another way to do that, there are a couple of ways you can do that. One is to have a prepayment, set up your funeral arrangements, which is not a bad idea, but also pay for it so it's ready to go, well, at your death. Same thing for the burial. The other way is maybe you have a small joint account with a child or someone else that has funds in it that can be quickly accessed after your death to pay for those expenses. So those are some thoughts. Uh, Jackie, do you have any other comments you'd like to add to that part?
I think just to emphasize that the documents you talked about at the start, the durable financial power of attorney and the healthcare power of attorney, just it is so much easier to have a simple document in place which puts someone in charge, even in the event of a temporary incapacity. You may have a surgery that goes slightly awry and someone needs to make a medical decision for you. It may not even be a full incompetency, but the documents themselves, if you have a trusted person to make medical decisions, if you cannot, or to step into your finances, if you cannot, even temporarily, and those may not be the same person, it's a very different skill set. But having these documents in place makes life so much easier for you, for the people who love you, for the people who care about you, for the neighbor who is suddenly in a situation helping you because there are no family and friends around. So, um, I think the importance of those documents cannot be overstated. Um, and I will touch upon or elaborate a bit about the will after death and your executor and the beneficiary designations in our next section.
Yeah, so our next section we're going to be talking about is probate. And, you hear a lot of people say you should avoid probate. Uh, Jackie, why don't you tell us what what is probate and do we really need to avoid it?
That's a very good question, Dan. And we are getting this more and more. Um, Probate is the legal procedure of either presenting your will to the local register of wills to be accepted as a valid will, hopefully, and have an executor appointed to handle your estate, carry out your wishes, pay final bills and taxes, distribute your estate. Um, if you do not have a will, there is still a probate procedure that involves, um, that falls under Pennsylvania intestacy laws. And so that will determine who is in charge or who has the right to serve and step forward. And the laws of the Commonwealth will determine how your assets are distributed. But it is basically the procedure for transferring the assets that are in your name alone after your death. Those are your probate assets. So for most married couples, they often own a lot of their assets jointly. Those are not probate assets. Married couples often designate their spouse as beneficiary on retirement accounts. Those are not probate assets. But plenty of husbands and wives own assets individually without a beneficiary designation, and those are probate assets. If you do have children at the death of the second spouse, most of your estate presumably is a probate asset. And so clients come in and say, well, maybe I should have a living trust. I should avoid probate. I've heard I should avoid probate at all costs. probate is not the same from state to state. And Dan and I have counseled countless clients over the fact that there are difficult probate states and there are straightforward probate states. So not all probate is created equally. Pennsylvania is a straightforward probate state. So that for most clients, a simple will do almost as much as, or more, or the same as a living trust. We are an inheritance tax state. And so, regardless of a simple will or a living trust, your heirs are subject to inheritance tax at a rate determined by Pennsylvania statute. Thankfully, spouses are 0%. Children and grandchildren are 4.5%, siblings 12, and the highest rate is 15% for nieces and nephews. But there is no reason to jump through a lot of extra hoops in Pennsylvania to avoid probate. The probate fees in the counties are relatively modest. As I said, it does not avoid the inheritance tax, which is sometimes what people are thinking the trust may do. We generally can probate a will within several weeks, if not a month, of someone's death. So it is not it's a process, but the process can be started relatively quickly.
I just, Jack, let me interrupt. And I'm sure you've had the same thing. I have often had the short certificate, which is the document evidencing you've probated within 10 days of death.
Absolutely. It's dependent upon the death certificate. And as quickly as you can get the death certificate, I tell my clients I can offer the will for probate as long as I have a certified copy of the death certificate. As soon as you can get that to me, I can prepare the petition and offer the will for probate and set up. We used to always do our probates in person. We now, in most of the counties, we do them by Zoom. And basically, the procedure is presenting your will and having it accepted as a valid will by the local register, and appointing that person who is now going to have the ability to transfer your assets, sell your assets, file your final income tax returns, oversee the payment of inheritance tax, make distributions to beneficiaries. So it's a very important step, but it's not an onerous step. And clients are being advised more and more to name beneficiaries on some of their investment accounts and bank accounts and avoid probate. And it's really not a one size fits all. So clients end up, possibly retitling assets. Living trusts tend to be more expensive and more onerous than simple wills. And at the end of the day, you haven't avoided the inheritance tax. You've possibly created a few more steps. And so our general rule of thumb is that a simple will, even if the will contains trust for beneficiaries, is probably going to work for most of our clients. The exceptions would be clients who own property in different states that is not covered by Pennsylvania probate. And so in those situations, I often recommend not so much a Jersey Shore house because we have relationships with New Jersey attorneys and we understand how New Jersey works, but clients who have property in Florida or Maine or Massachusetts, then I'll recommend you may want a trust for that property. You may want to even connect with an attorney in that state for that property. But for most of us, a will is going to do what we need in Pennsylvania. There are, following up to something Dan started to mention, um, situations where we recommend that you do designate a beneficiary on your account. Retirement accounts, designating a beneficiary makes that a non-probate asset, but it also gives your beneficiary the opportunity to take advantage of some income tax consequences to spread out the withdrawal of that inherited IRA. And I think the most important thing is that you have a plan where your simple will does not conflict with beneficiary designations, and that your beneficiary designations are in line with your will. Um, People ask about joint accounts. A lot of people are worried that at their death, their adult child or their dear friend or their sibling will not have immediate access to funds to pay bills. The truth is, aside from the funeral bill, there are not that many bills that are due immediately upon death. And so the time for probate, as Dan said, 10 days, 2 weeks, 3 weeks. Occasionally a bill is paid late, but people usually understand when you tell them someone has died. They often wipe out any fees or extra charges. So there's not an immediate necessity to have access to money, but I have suggested to clients, if you add a trusted person to an account, make them a joint owner, yes, they will have immediate access, but you have to be sure that that person recognizes that this is a convenience titling. This is not necessarily a gift, because under Pennsylvania law, you have, in fact, made a gift if you predeceased that person. So they could choose not to use the funds for the funeral or your ongoing house expenses. Um, so that's another thing to consider. The bottom line being, when it comes to a will versus a trust in Pennsylvania, is that as a straightforward probate state, Commonwealth, um, we rarely advise clients to create living trusts, retitle their assets into the trusts, to avoid probate.
I'm not sure whether this is something to come up now. There's a question in chat. I heard the word trust here, and maybe this comes later. Please explain the pros and cons of putting one's home into a trust. Is this a good time for that, or should we hold off?
Jack,
What
I
do you
think it's a
think?
good time for that.
I think it's a good time. The house is, it's similar, but also more complicated, on one level. But what are you trying to gain by placing the house in trust? It's true that it's no longer a probate asset. At the time of your death, a death certificate would be required to transfer the property to the beneficiary with a new deed. But the house is still subject to the full Pennsylvania inheritance tax. And in a lot of estates, the house is a major source of funds that, the house needs to be sold in order to pay the final debts and the expenses and the inheritance tax. So it's a rare situation where I advise placing a house in trust versus, even if you have decided to give the house specifically to a beneficiary, oftentimes a simple bequest in the will is enough.
Me too.
You just don't gain a lot.
Yeah. So again, I think both Jackie and I want to emphasize some pitfalls. We're hearing more and more financial advisors saying you need to name beneficiaries for your investment accounts. It's called transfer on death or pay on death.
Mhm.
And including some really outrageous ones we've seen would say if you don't, you risk having all the property go to the state. That isn't going to happen if you have any family or children, because even if you don't have a will, intestacy is going to give it to your spouse or your children.
Right.
Uh,
Even if you have cousins, even if
Cousin,
you
yeah.
have a cousin who you don't speak to, and
So, I
I've
mean,
had it.
it is a gross overstatement what some of these financial firms are saying. And if all of your accounts have beneficiaries, that leaves you with no funds to pay debts, expenses, and taxes. I had one client who said, "Well, that won't be an issue." I said, "Okay, you have three kids. Well, all three kick in equally." Sure. Oh, maybe not. Maybe John will be a little reluctant to give money back. There are just lots of issues on that.
And
Second,
yeah,
go
I'm
ahead.
sorry, Danny. We've had this more and more. And again, it's important to remember when you're hearing about the importance of avoiding probate and creating a living trust, that not all states are equal. And so I have clients who their parent died in Ohio or New York or Florida, and that investment broker said you need to their client, you need to have beneficiaries on these accounts. And and then the client becomes a resident of Pennsylvania, and they're shocked when I say to them, well, you each got $100,000, but I have to ask you each for $4,500 back because you owe Pennsylvania inheritance tax. So it's it creates a too many cooks in the kitchen in a lot of situations. You ideally in an administration, in order for it to run smoothly, there is someone in charge. There is someone in charge of the necessary funds to pay all the final expenses and taxes and then make the distributions to beneficiaries. We don't like being in a position to ask people to give money back because people don't like to do that.
Yeah. Another point is beneficiary designations. When you say pay on death to my children, etc., are not always very good at dealing with unusual situations. One of your children predeceases you. Does that child's share go to that child's children, or does it go to your other children? Things like that. When some financial advisor gets you to sign one of these beneficiary designations, they don't go through issues like that of what you want. So
Right.
again, that's why a good will deals well with these situations. And again,
The main goal in Pennsylvania really should not be avoiding probate. There are too many nuanced issues. And just adding on to what Dan said, special beneficiaries, you don't even need a child that's predeceased, although that does create a lot of issues. We have adult children and grandchildren, they are suffering from substance abuse. They are suffering from mental illness. We have simple trust language in our documents that allows us to protect that beneficiary, to allow us to set that money aside for their use. Um, we have senior siblings who are already on the road to Medicare. I'm sorry, Medicaid, and they really don't need to be inheriting from their siblings. So again, the beneficiary designation, often for estate planning purposes in Pennsylvania, ties our hands or creates a situation that isn't really necessary and often not ideal. And often creates more work and headache, actually.
I have been practicing for over 50 years. I've been on the um, executive committee of the probate section, and I can tell you that this is something that we have talked about extensively at meetings of the executive committee. The these people, the financial firms, giving this advice without understanding what a will can do that a beneficiary designation doesn't do. So this is a hot button for any knowledgeable attorney in dealing with these issues. And then lastly, just remind you again, changing a will does not change a beneficiary designation. That's why when you're reviewing your documents, you need to review everything, not just some of it. Any other comments, Jackie, before we move on?
Absolutely. No, I think I'm ready.
Okay. Okay, we're
Okay, before
already
you move
running
on, you've got
close
a couple,
to,
Dan, you've got a couple questions here that relate directly. First of all, well, given all you're saying, is it better to give your family money before you die from a tax point of view?
well, the simple answer there is, um, well, I'll give you a great example that I heard umpteen times from my grandfather. He had a neighbor whose son said, look, Dad, let's avoid taxes. Give me your money. Transfer your money to me and, I'll take care of you. My grandfather's neighbor did. The grandfather's neighbor's son kind of forgot about that and left his father destitute.
Well, that's an extreme case. Where is the that's an extreme? I
No,
mean,
but
this
it
is
is. I mean, it's something you need to worry about, Faye.
Right.
well, but all right, so we're not going to give it all away, but
So
might it be good to give it away moderately and avoid some of this?
I will say that I have clients who are finding themselves having more money than they imagined that they might. They worked hard, they saved, their investments grew, and they are, and I'm not talking about, you know, a lot of people have more money than they expected to have. And so I think there is room for gift giving I think there's a lot to be said about having the pleasure of giving a gift while you're living and see it appreciated and see it used. I rarely advise clients to make gifts to avoid Pennsylvania inheritance tax. For children and grandchildren, it's 4.5%. That's not compelling to me. Um, you can't give away too much money. You want to make sure that you have enough money. You could also, and people are living longer. You could have a lot of health care needs. And so, um, the reason to give should be an informed decision. And I think the pleasure of giving while you're living, especially if you get to a point where you realize I'm not going to be able to travel. I've estimated what if I need long-term care for 5 years or 8 years or 10 years, and I'm still going to have a nice cushion. I think it's nice to consider gifting, but I don't think it's our federal estate tax, which we haven't mentioned, but that's because it doesn't apply to most people. I think couples are at about $27 million, something like that. So we're not focused on that right now, but I think a gifting conversation is worth having with your attorney and your spouse, just making sure that you're doing it for the right reasons, not to um, disable yourself in any way. I mean, if you go into a retirement community, they will look at your assets and your available resources, and that will determine the level of retirement community that you can enter. Um, So it's a good discussion to have.
And
One
if you're in a
one other,
retirement community and you've given your financial disclosure, and then you go ahead and make significant gifts that jeopardize your ability in later years to pay your bills, that would be considered a breach of the contract with the retirement community. So you need, you've committed to make sure that you've tried to keep funds available. It's different if you run out of money simply because your expenses were more, but if it's because you've made significant gifts, that isn't going to sit well with the retirement community. So
okay,
what I
well,
tell clients is your obligation is to provide for yourself and your spouse. You have no obligation to provide for your kids once you've educated them. Faye, I interrupted you.
yeah, well, I know we're going to need to move along, and I think these two questions are probably pretty quick. One is, if your children live out of state or in another country, do they still have to pay inheritance taxes?
The inheritance tax is a tax on inheriting property imposed by Pennsylvania. Pennsylvania doesn't care where you live, whether you live in Pennsylvania, Florida, or in that new colony on the moon that we're going to have shortly. You'll still pay inheritance tax.
Right. It
Okay, another,
follows where the decedent lives. So yes, it follows the decedent, not the beneficiary.
okay, another maybe quick question. Are there different considerations for the named beneficiary versus named in a will for a Roth IRA versus a traditional IRA?
Sure. I mean, that's right up my alley. The beauty of a Roth IRA is that it's all of the income tax has already been paid, so it comes out to your beneficiary free of income tax. One, two, distribution of it can be spread over several years. So in giving that to a family member, your children, giving it to your children, that is a tremendously valuable asset to inherit. So that income tax difference says if it's a Roth, I want that to go to my family, to my individual beneficiaries. If it's a regular IRA, that's the source for your charitable gifts.
Okay, all right, maybe we better move on here because I see time running out here.
Okay. So this we're going to move just fairly quickly on. Choosing your executor and who handles your financial and medical decisions. In many cases, you'll choose the same person to manage your finances, to be the agent under your power of attorney and to be your executor in your will, as well as to be your healthcare agent. But sometimes I've had a number of clients say, well, this child would be very good about managing my finances, but really isn't going to be very good about making medical decisions. This other child or this very close friend, that's who I want to make my medical decisions. So think about when you're deciding who to name, think about the difference in the kinds of responsibilities. Do you have a single agent, multiple agents? Well, we're running into a very, I think, unusual and outrageous situation right now. One of the banks, Wells Fargo, says if you name co-executors, we won't open a bank account for you. We can't deal with co-executors. You have to have name a single executor. I think that's extreme. I think that's outrageous, but it's a reality that sometimes can be a problem. Otherwise, maybe it's good to have more than one person kind of consulting, making the decisions. Uh, when you're talking about managing, whether it's I say out of state executive, it's also true about power of attorney. If you have someone that isn't living in this area, trying to handle your finances long distance, that's hard. So think long and hard about whether you want to do that. It's not quite as hard for an executor as it is for an agent under a power of attorney, because agent under power of attorney, there's constant things that need to be done.
Especially Dan, and I will just add that although in 2025, this should not be as important. We are finding the banks are so worried about fraud that transactions that should be able to be done with documentation and by mail and phone and email and even e-signing, a lot of the banks are not there yet. And you need to be in person as an executor, as a financial power of attorney. And so I caution my clients, it's you want the right person, but if the right person is in California, it's going to make life a little bit harder because we're just not there yet.
Good point. Good point. So you've got lots of choices. Most people, late in my recent experience, have been choosing family members to handle these affairs. Um, we're having a discussion here at Cathedral Village, which I'll be interested to see what comes of it. That there are obviously some people here who don't have family members, and they're having a hard time figuring out who to choose. And there is no easy answer to that. Traditionally, it used to be the most common choice was to name a bank. The problem is that I don't know where I'd draw the line, but I'd say probably much under $1 million, the bank fees are sufficient that they become prohibitive to name a bank to be the executor under your will. Lawyer, in the past, I've resisted being an agent under a power of attorney. I've done it for a couple of clients, or being an executor, but it is a choice. And I think because of banks pricing themselves out of the market, it's going to become more common to think about that. Some people talk about their financial advisor. Many financial advisory firms say, no, that's a conflict of interest and won't allow you to do it. Friend, it's a big responsibility for a friend. Think long and hard about whether you want to ask a friend to do it. Jackie, before we move on, any comments?
I'll just add that our office has found ourselves being asked more and more to potentially assume the role as executor because of um, all of these issues that we just named. And maybe there aren't family members, maybe they live very far away. The bank fees are prohibitive, and that's a responsibility we take very seriously. And we are willing to do it, but that also, that compels a stronger relationship because occasionally we're asked to be a financial power of attorney. And people, there are just, there are people, as Dan alluded to at Cathedral Village, they just don't have a logical person. And yet, of course, they have, they know what they'd like to happen at their death, and they want to hope that it's carried out according to law and that the people or charities benefit. And so we find ourselves being asked more and more, I think, because of a lot of these issues.
All right, we're going to just cover the last very, very quickly.
One quick comment before you go on. It was put in chat here that PNC will open an account for co-executors.
Yes, I just mentioned Wells Fargo because I've had some both Jackie and I and many other attorneys have had some bad experiences recently with Wells Fargo, unfortunately.
Yeah. I mean, most of the banks will and they should, but I mean, Wells Fargo makes up their own rules. So,
All right, Jackie.
okay. So at the end here, we have a little hodgepodge, and I'll just try to run through them quickly. Should I treat my children equally? My one child is wildly successful. The other is barely making ends meet. As parents, we often feel we need to treat our children equally, but that is a consideration. If you decide not to treat children equally, Dan and I were talking earlier today. Maybe it's a good idea to have this discussion with your adult children. And if you don't feel comfortable doing that because you might change your mind, circumstances could change, maybe have a side letter that explains what might be obvious, but why you did what you did, and that it's not about love and affection. It's more practical. Where should I keep my documents and whom should I tell? Um, we have a lot of local branches that are closing. With that, they've closed their safe deposit boxes. People traditionally kept their documents there. A lot of times, if you are meeting with an estate planning attorney to prepare your documents, often they will hold your documents. That's an option. Um, Maybe a safe at home. Who should I tell? The last thing I say to my clients is, especially in a situation where maybe it's a single person with no adult children or no adult children local, if no one knows you did your documents, it's almost as if you didn't do them. So make sure your adult child, maybe even your next door neighbor, if that's the case, or your cousin in Iowa who's going to be the operative person, make sure they know you met with an attorney, you prepared documents, where are the documents? Um, I don't know that you have to tell your family that much more than that. If you meet with a reputable estate planning attorney, we're going to take information about where your assets are, who prepares your income tax returns. We can provide that to the family in the event of your death if they come to us to get your will. Um, and last but not least, passwords for computers and online accounts. It's interesting, and I hope this puts people's minds at ease to a certain extent, but your password is really for you while you're living. And at the time of your death, um, there will be a new entity created, and it's an estate account, and your executor will create a new password. With that said, it is certainly a good idea if you are someone who keeps good track of your passwords and has a good system to give that in a sealed envelope to your estate planning attorney to keep with your original will, or to give that to the adult child or the trusted friend or neighbor or cousin who will be your executor. It certainly can't help. It certainly can't hurt, and in some cases, it is really needed and can create different problems if people have passwords to things that other people can't access without the password. But for the most part, with your bank accounts, your investment accounts, your house, um, we can administer the estate without your password. So you shouldn't be overly worried about that.
Thank you. We have some good questions popping up. One is, it's not so much a question as a statement. Marilyn Silverstein says, as a former hospital social worker, I emphasize the importance of sharing your advanced directive details with your family and loved ones. Don't let the paper tell your story. Make sure your designated representative understands and approves your decisions. But then two questions. One is thoughts on life insurance to cover end-of-life expenses.
That can be a particularly good choice if you, let's say your principal asset is your house. You can't just write a check because you have a house to your executor to pay the bills. It can take a while to raise the funds. So life insurance can be a very valuable source to deal with illiquidity.
I completely agree with that, and will also add that I've had situations where clients designate a beneficiary of the life insurance with the intent that they will use that for the estate expenses. But when it is explained to the beneficiary that this is actually a gift to them, they are not always as inclined to use it for the estate expenses. So, life insurance is not subject to inheritance tax, it's not subject to income tax. And so, if you are worried, because that's a perfect example that the house is the main asset or the condo, having a a modest 10,000, 25,000, even 50,000 life insurance policy that's payable to your estate may give your executor the funds they need to administer your estate before that main asset is sold, and that's a good plan.
Okay, let
Another
me
quick
just pick up on a question that I see that just got added. I'm confused about your distinction of beneficiaries designated for IRAs and within the will. I assume that IRA distributions are enumerated in the will. Absolutely not. Those are two separate documents. If I say to my will, in my will, that all my assets go to Faye, my wife, that does not affect my IRA. So if I decide to make my IRA payable to our three sons, no matter what I do to my will, it doesn't change it. That's why you need to look at both documents, both the will and the IRA beneficiary designation, because the IRA beneficiary designation does not affect your will, and your will does not affect your IRA beneficiary designation.
And the IRA is very different from your investment account. They're just completely different implications. So, what we're trying to emphasize is your beneficiary designations on your retirement account should be in line with your plan in your will, but your investment accounts should be covered in your will and not with a beneficiary designation.
Thank you, Jackie. That's very clearly stated, I hope.
Okay, now some other quick questions here. What does payable to the estate mean?
Well, you can make your life insurance payable to your estate. That would then give your executor the funds to pay the bills, and making it payable to the estate, it's still exempt from inheritance tax. So that can be a very good way of providing funds when you're in an illiquid situation. Illiquid meaning you don't have any cash assets,
Mhm.
that are assets easily and quickly converted to cash, like real estate.
And I will just add, Dan and I chatted earlier today, and this is especially important. Occasionally, I have clients who they think of their assets very piecemeal, and they want to give this account to one person and another account to another person, and maybe the house to this person. And that is a recipe for disaster because that does not give the executor the funds to administer the estate. But that's an example of where if a client is very insistent, they think about it in a certain way and they want this there and that there. Life insurance is a way that you can make that plan work with, that plan.
Okay,
Okay,
another question is, when should you sign your power of attorney documents? So there's two different signatures on a power of attorney. One is your signature granting the power of attorney. That power of attorney cannot be used with just that signature. And maybe it should have two witnesses and a notary, but there's a further step before it can be used. And that is your agent has to sign it saying, I understand that I'm not dealing with my own assets. I'm dealing with the principal's assets, and I will respect that difference. It's basically the thrust of what that is. Before the power of attorney can be used, that also has to be signed. So one of the protections that I have used over the years, and back in the days of at Drink a Biddle and Wreath, even 50 years ago, when we did a power of attorney for a client, we kept the power of attorney, if with the client's permission, in our will vault. and only released it when the client needed it. The client was suddenly incapacitated and needed someone to handle the financial affairs. So while it's a valid power of attorney, if you don't have it, you can't use it. So that's a kind of a protection that we have. And Barbara Sharp and Rosenberger has a vault to keep powers of attorney and like that. Commons and Commons, where I was a few years ago, they have a vault for keeping it. So it's this is not unusual.
Which we're talking about the executor. One of the questions was, what is the traditional executor fee?
That's a good question. That is a good question. There is somewhat dated Pennsylvania case law, which sets a schedule of appropriate fees for an executor, and it depends upon the nature of the assets. I say to clients generally, and I know we don't have all the time in the world, but an appropriate executor's fee could be in the 2 to 3 to 4% range, depending upon the nature of the estate, the
And the
assets,
size.
the size, yeah, the size of the estate, the number of beneficiaries, the assets involved. So executors are entitled to be paid. It is a job, and an executor needs to claim their executor's fee on their income tax return. So sometimes clients want a specific executor's fee in the will. They want to make sure that an executor, especially a friend, or someone who's acting. A lot of times, if it's a family member and they're also a beneficiary, they'll waive that fee because they're inheriting and they see it as an obligation and a duty. But it's for discussion for sure. But it could be a modest percentage of the size of the estate.
I've heard friends say it's a big job.
It's a big responsibility. It is. Even when you hire an attorney who administers the estate for you, you are overseeing everything. You're signing off on everything. And I think generally speaking, executors feel like, wow, this is a little bit more than I thought it was going to be. Um, but, that's what Dan and I do for a living. So,
Now, I see in the chat a comment from Marilyn Silverstein, which is, I think, a very good point. So, in case you haven't seen it, as a former hospital social worker, I emphasize the importance of sharing your advance directive details with your family loved ones. Don't let the paper tell your story. Make sure your designated representative understands and approves your decisions. That I cannot tell you how important that is. As she says, seeing it on the paper versus talking uh, to your family and making sure they know what you want uh, is absolutely critical. Faye and I have had a number of discussions on that that go far beyond what Faye has in the document. She wants to make sure that I follow, that I really understand what her wishes are. So that's a very important point. Thank you, Marilyn.
I think we've hit all the questions unless somebody has, and we're pretty much right on schedule, but if someone has something, this is the time. I think our attorneys are willing to stay a few minutes longer if you have a specific question. We've covered a lot of material here. It has been recorded. It will be posted on the bulletin board for Northwest Village Network, and I think we can get it over to the other two villages. Who sets the executor's fee? I think that was sort of answered, wasn't it? It's worked out ahead of time, kind of.
as the will writer, you can set an executor's fee. I've had clients say to me, I want to be sure I know my cousin will not take it unless I say I insist that she take a 2%, a 3%, occasionally I've had a client say, I do not want my executor to take a fee, and I don't feel comfortable with that, but occasionally they've said, I'm giving a gift and I don't. So you can set the fee as the writer of the will. But otherwise, we're going to look to Pennsylvania statute. We're going to give the executor options and we'll come to something that they're comfortable with, or they may say, I'm going to waive it.
And just one point I want to make on that. Nominally, the executor sets the fee, but every executor is accountable to the beneficiaries. If the beneficiaries think that the executors charged too much or done a bad job, there's always the possibility of demanding that the executor file an account in orphans court of every single action the executor has done, and then challenging any action of the executor. Now, having said that, I have had that challenge happen. I don't think I could count it in the states I've administered on one hand. I think I've had it that I don't think it goes past the 5 times. It's very rare, but it is the ultimate protection of the beneficiaries.
That's a
Uh,
very good point, Dan. You're absolutely right. It's not just up to the executor. It has to pass muster, so to speak. And like you, I have had very like less than one, if one maybe instance where a beneficiary has questioned an executor's fee, and usually we would work that out. But people, when you choose someone to carry out your final wishes after you're gone, the most important thing is to put some thought into that and make sure the person is not just someone who loves you, but someone who is capable and able. Again, they can hire an attorney to assist them, and that's recommended in a lot of situations, but so they don't have to become an expert estate administrator. But you need, usually, if you find the right person, the executor's fee is not going to be an issue in almost all estate administrations.
We've got three more here, and then maybe we should end with
yeah,
those.
and also Yoav has raised his hand.
Johan's one of
If
the three. You want to take Johan first?
Sure.
Sure.
Yeah, if I can add regarding the passwords, I mean, this is something that I'm dealing with it on a daily basis. If you give the list of all those passwords to your attorney or something, they are being changed all the time. It's not something that it's a dynamic thing. So the issue is, the trick is to have a password manager that has like a master password to it. You give this master password to the attorney in the envelope, and then you can change your passwords all the time. And when the bad things happen, bad things happen, they open the envelope and everything is current there. That's my 2 cents.
Good.
Thank you, Yoav.
Okay, here's a quick one, I think. If a person drew up a will in another state, is it necessary to update it for Pennsylvania?
It's always a good idea to review it. The basic point is, under federal law, a document that is valid in the jurisdiction where it was executed is valid in all states. That said, there may be differences in the law that might cause you to want to do things differently. So it's always a good idea when you move from one state to another to have your documents reviewed by an attorney in the state to which you're moving.
And I often say to clients, even though your will may be perfectly fine, Pennsylvania has its own financial power of attorney. And so if you move to a new state, you're just going to make life easier for yourself and your agent, your beneficiaries. I'll say to clients, your will is fine. I would just be doing the same thing, but it's the financial power of attorney that I want you to do in conformity with PA. And at that point, it usually makes sense to just update them all.
Yeah. Okay.
Okay, question here. Do IRAs inherited by children have to be counted as income within a specified period of time?
Well, any IRA that's inherited has minimum distribution requirements. The minimum distribution requirements have gotten a little bit more complicated. But assuming you have individuals as beneficiaries, there are one and potentially two rules which apply, and there's a bunch of exceptions. The basic requirement, basic rule, if it's individuals inheriting, is that it all must be distributed by December 31 of the 10th year following the year in which you die. Now, if when you died you had passed your required beginning date, then there are also annual minimum distribution requirements. And then there's one of the major exceptions, which is easy to forget, and I've got it in an estate right now. If your beneficiary is no more than 10 years younger than you, then that 10-year-old does not apply, and you can just simply use the minimum distribution tables, which are based upon your life expectancy, the inherited person's life expectancy in the year following the year of death. Those rules are complicated. I've spent a lot of time studying them, and all I can say is when someone inherits, they need to consult someone who knows what they're doing with those rules. The biggest mistake I see is, oh, hey, I just inherited 100,000 IRA, pay it to me. And then suddenly they have 100,000 of income in 1 year. That's not a very smart decision.
And I will just add, because I think I saw something in the chat, and so the difference between $1 million investment account and $1 million retirement account is very different. With your $1 million investment account, if it is distributed under the terms of your will, because it is a probate asset and it has no beneficiary designation,
Or if it is a
that
beneficiary
account will get
designation, same rule if there's a beneficiary
same rule,
designation.
same rule, but that asset will get a step up in cost basis as of the date of the decedent's death. And if you liquidate that account, you can't liquidate it the next day necessarily, but you could potentially receive $1 million plus or minus with very little, if any, income tax consequence. It's the opposite with the $1 million retirement account. It's all subject to income tax. And so, as Dan said, you want to speak to someone who's knowledgeable and make some good decisions for yourself. You have some control and you have time on your side, and make some good decisions.
Now, let me just add something that was mentioned in the outline but not followed through on. Some financial advisors will encourage you to buy annuities. Annuities do not get a step up in basis at your death. And not, moreover, the portion that's income isn't even capital gain, it's ordinary income. So think long and hard about whether you really need an annuity. If you're doing it just for investment purposes, in my opinion, the principal beneficiary of your buying an annuity for investment purposes is the broker who sold it to you and who gets the commission for selling it to you. Don't jump at annuities.
All right, I keep promising the last question. This has got to be the last one, but it's a quick one, I think. If contents of safety deposit boxes are, or of a safety deposit box, are in the name of several individuals, are the contents all considered part of the estate of just one of them?
I don't, well, I mean, it depends. I mean, obviously, if it's a deed to a house, an important document, that says who it belongs to. But if it is things like jewelry, etc., I fortunately have not had to deal with this other than husband and wife. I think that would be considered jointly owned.
I agree. I think most people, if it's not husband and wife, you're better off if you're using a safe deposit box, naming someone as deputy or power of attorney on the box, not owning it jointly with your adult child, because the potential is there that if you're keeping the $1 million diamond necklace in that box, yes, like most joint assets, you've created a gift. If you die and the surviving joint owner now owns the box, but we don't see that much.
So yeah, I've heard lately that a lot of banks are phasing out boxes. Well,
Yes.
Mhm.
we've gone past our time. I think, thank you for our attorneys. I think we should give them a virtual hand clapping. Glad you could all join us, and we will see you again, and hope you got a lot out of this. I'm seeing a lot of complimentary comments in the chat, so I hope our attorneys will take a quick look at them. So thank you for joining us tonight. We covered a lot of ground. I know my head's a little bit spinning, and thank you for coming on behalf of NVN.